When can you oppose a trademark application? Imagine seeing a new product hitting the shelves and thinking, wait a minute, that looks just like a brand I already own. Or maybe you're concerned that a new mark might confuse your customers. When can you step in and say no to that trademark? You can oppose a trademark application only after it has been published for opposition. This happens once the United States Patent and Trademark Office, or USPTO, approves the application and makes it public. The publication appears in the official gazette, which is like a notice board for new trademarks. Once published, a 30-day window opens for opposition. During this time, anyone who believes they could be harmed by the registration can file a notice of opposition. If needed, this period can sometimes be extended up to 6 months if the opposer requests it and the USPTO agrees. To oppose successfully, you need to have a valid reason and a legitimate interest. This means you must show that your rights or interests could be damaged if the mark is registered. For example, if you already own a similar trademark, or if the new mark might cause confusion among consumers, you have grounds to oppose. The most common reason for opposition is the likelihood of confusion. If the new mark looks or sounds similar to your existing trademark and could lead customers to mistake one for the other, that's a strong reason to oppose. Other grounds include if the mark is generic or descriptive, if it dilutes a famous mark, or if it falsely suggests a connection or sponsorship. You can also oppose if the applicant is trying to trademark a surname. If the application contains false information or was made fraudulently, or if you hold a prior registration for a similar mark covering related goods or services. The opposition process is handled through the Trademark Trial and Appeal Board, or TTAB. Think of it as a less formal court where both sides present their case. The opposer files the notice of opposition within the 30-day window, and the applicant then has a set time to respond with a counterstatement. If the opposer proves at least one valid ground, the mark will not be registered. If no opposition is filed within the time frame, the application moves forward to registration or to a notice of allowance, especially in cases of intent-to-use applications. So, in simple terms, you can oppose a trademark only after it is published for opposition and within the specific period. Your opposition must be based on clear legal reasons that show how the registration could harm your rights or interests. Knowing these rules helps protect your brand and ensures fair competition in the marketplace.